The Constitution itself has prescribed the mode by which an enactment properly so called can come into being, and by the principle of separation of powers, those processes must be exhausted to produce a tangible product that can have legal effect when properly assented to by the President, the head of the executive. Until there is presidential assent, there is no act Parliament over which the Supreme Court can act of Parliament over which the Supreme Court can exercise its original jurisdiction to strike down if found to be inconsistent with the Constitution 1992. The plaintiff's action is therefore dismissed.
The controversies surrounding the anti-gay bill have been put to rest after a 7-member panel of the Supreme Court has unanimously dismissed 2 separate writs, one filed by Richard Delasky and another by a researcher, Dr. Amanda Odoi, at the Supreme Court, challenging processes leading to the passage of the anti-gay bill. What the Supreme Court is saying is that the writs that were filed by the 2 individuals have no legs to stand on, because at the time that they were coming to court, the processes were still on for the passage and there was no act to be challenged, especially so also when the President has not assented to it. In this regard, they unanimously dismissed those 2 separate writs. The plaintiffs and their respective lawyers have been reacting to the decision of the Supreme Court because they do not have the full reasoning of the decision made by the apex court.
I don't want to preempt the reason of the court. I heard Article 130 being quoted that the action is premature because the bill had not blossomed into an act. Therefore, we had no right to come to court. But please, for now, it is just a tip of the iceberg. Let's get a full judgment, look at it with the lawyers' lenses, then possibly advise our clients on the next step to take.
The decision of the Supreme Court is final, but this is not final. There is another leg of finality to go. There is a review jurisdiction of the Supreme Court, which is available to us if we want to use it. And so it's not final yet.
We're proceeding on procedural grounds, so we still have options. Yes, but as we have said, we will wait to hear to see what is in the judgment. I am surprised and disappointed.
What is clear now is that Parliament is free to deal with the matter, transfer the bill to the presidency. But what is clear also is that once the parties get the full reasoning, they are properly able to inform themselves on the next line of action as to whether to seek a review or not. But what is clear is that the 2 separate writs have been unanimously dismissed by the Supreme Court. From the Supreme Court here in Accra, Murtala, Inusah, GHOne.